Good afternoon. Good afternoon, everyone. And thank you all for taking the time to join this Finance Malta webinar, which I am happy to say has attracted over 260 participants. Thank you. Thank you for your interest. Today's discussion title states, Compliance remains high on Malta's agenda. I actually dare say that compliance remains high on every agenda. We know that it plays a very important role in today's corporate world. We know that the role of compliance, MLROs, has become one of the most important functions in regulated businesses today. Paul McNulty, a former US Deputy Attorney General, once said, if you think compliance is expensive, try non-compliance. So that's food for thought. And that's why we are very happy to have with us this afternoon Fran, Moisa and Charles Cassar, who will also discuss the evolving role of compliance MLROs in a local and international context. Fran is the founder of FM Search, a boutique recruitment, headhunting and talent advisory firm with over 12 years experience in both London and Malta. Fran has assisted many international businesses with recruitment and staff retention in highly competitive markets. Charles is the founder of Shoulder Compliance, an anti-financial crime consultancy focusing on AML CFT, sanctions, and anti-market abuse. Charles has many years of experience leading the compliance function of a European systematically important institution, as well as a commercial lawyer and heading the legal and compliance departments of a fintech bank. We'd also like to hear from you, the delegates, your opinions, your thoughts. So feel free to use the chat function on your screens to share these thoughts. Don't worry, only the panelists will be able to see your chat or comment. So, Fran, Charles, over to you. Thank you.
Thank you so much, Ivan, for the kind introduction, and thank you everyone for joining us today. Charles, lovely to be speaking with you again on a still very important subject and an ever-evolving subject, which is AML compliance and the importance that it carries both locally, but as well as at an EU and, of course, global level as well. And the regulatory environment continues to evolve, and it has evolved beyond recognition throughout the years. And what is the next step on the horizon that is facing us at the moment is the single AML rulebook. So what changes can we expect when this single rulebook is adopted and implemented throughout the EU member states?
Okay, so I think the single rulebook for AML is probably going to be the next major milestone in the evolution of the AML CFT framework. Just by way of background, we are currently still more or less living in the AML4 world, in the world of the fourth directive. Yes, there has been a fifth AML directive and some other legislative developments, but the core of the current framework is the fourth AML directive, and that brought about a number of important changes. I think most of all, the emphasis on transparency of beneficial ownership and the emphasis on the risk-based approach. Now we're approaching the next big milestone, which is what we're calling the Unified Directive or the single rule book, right? And I guess the single rule book really is, well, in my head, it's two things, right? On the one hand, there is a drive to achieve far greater levels of harmonization across the European Union in terms of the substance of the rule set. And secondly, there is a drive towards ensuring that there is pan-European supervision. And I think this second one is probably the most visible and dramatic change that we're going to observe, because effectively we're going to see the introduction of an AML authority, the AMLA or AMLA, right? Which is going to be a sort of regulator's regulator, kind of like an ECB for AML related matters. And that's going to be a massive change. Because although, you know, we've had an AML CFT framework now for a couple of decades or so in some shape or form, right? But that has always been implemented by domestic regulators, by domestic legislators. And very importantly, it's always been enforced by domestic regulators and domestic legislators, and always been interpreted in a domestic way. So what that means is that although we have a European level directive in one form or the other, there's been a lot of fragmentation in terms of the interpretation of those rules. And there's also been a lot of difference in terms of, you know, enforcement expectations and structures. So we're going to have an AMLA, a European level authority, which is going to act as a regulator. And although many subject persons will not necessarily have a direct interaction with the AMLA, it will be something, I believe, which people will feel the impact of, you know, at least indirectly.
Thank you, Charles, for the summary. And one of the other areas that was mentioned there was with regards to the increased scope of obliged entities that would fall under the AML CF2 rules or the 6th directive that is being proposed as well. And this comes at the same time. So we have an increased scope and greater harmonization of the legislation across the EU states with a far greater remit than we've had to date, whilst at the same time we have the, you know, AMLA, or the, you know, let's call it the regulator of the regulator, sort of overarching at a local level. How can Malta as a small jurisdiction cope with these upcoming changes as well?
Okay, so let's unpack that, because I think there's almost like 3 questions in there. So let's
3 questions into one.
Let's try to, so that's very efficient. So, you know, so let's try to unpack this. So I think number 1, we probably need to speak a little bit more about the AMLA, right? So the AMLA is going to be, I like to call it a regulator's regulator, because the let's say primary focus of the AMLA is going to be top level standard setting, ensuring coordination between regulators and making sure that regulators adhere to the standards that they are supposed to adhere to. This is the main focus on the AMLA. It is clearly motivated by, let's say, a political desire to ensure that all regulators are pulling on the same rope and in the same way and cooperating with each other, and that we don't have regulators that are stricter than others or that implement things differently to one another. So that is the main thrust of it. Now, that's not going to be the end of it, because the AMLA will also, at least under the form of the current proposals, right, will also have the ability to regulate directly the entities which are considered riskiest within a jurisdiction, right? So it will regulate certain entities directly. And if it is, let's say, somehow dissatisfied with the quality of supervision that any particular regulator is exercising, they will be able to sort of have step-in rights where they actually intervene directly or guide the local regulator directly in terms of what needs to be done. Now, in practice, what that means is that life might change quite dramatically for a few firms which are directly captured by the AMLA. As Ivan said during my introduction, you know, in a previous life, I was head of compliance of a systemically important institution in Malta. That means direct regulation by the ECB. Direct regulation by ECB is something to be taken very seriously. It is a very high and exigent level of regulation. And let's put it this way, you know, they were very well resourced, very on the ball. And we definitely felt the impact of that level of regulation. Also bearing in mind that for Maltese entities, you know, something which everyone should remember is, unfortunately, sometimes the European level authorities don't necessarily implement proportionality principles very well. So we may have, in our country at least, institutions which by a European standard are relatively small, which are faced by the challenge of direct top European level regulation, which is not something to be taken lightly. Now, Other smaller institutions will not be subject to direct supervision by the AMLA, but I think at the end of the day, they will feel the indirect impact of the existence of a sort of supranational regulator, which is always ensuring that the local domestic authorities are performing all of their obligations to the very, very highest standards. So I think that's the AMLA bit of the question. And then there's the other bit of the question, which I think is the continuing expansion of the scope of the AML directives. Now, this is basically, it's become routine pretty much that with every new directive, we have an expansion in the number of areas which are actually captured by the scope of the AML regime. We're going to see that again among the new market players that are going to be captured within scope of the directives. We're going to have crowdfunding service providers. We're going to have mortgage or credit intermediaries, which are going to be captured as well. We're going to see the capture of citizenship by investment agencies to the extent that they deal with non-EU citizens. And I think we're also going to see the full capture of the remaining parts of the cryptocurrency service providers markets. Previously, the directives would only capture you if the transactions you are dealing with had a fiat leg to them. I believe now those distinctions are going to fall away, and the current drafts would capture effectively all cryptocurrency or virtual currency service providers. So we're going to see another notable expansion in the remit of the directives, right? And obviously, if you're captured by that expansion, then in that case, yes, your life is probably going to change quite dramatically. Although, to be fair, some of these industries have already been getting ahead of things and have already been kind of tooling themselves up to an AML4 standard, more or less. But it's always different when you're actually captured directly by the rule. So that's the second part of the question, right?
Correct.
It was kind of like maybe sort of how do we deal with all of this, right?
Exactly. So how will this impact and affect Malta-based entities? I'm not going to say the second part of the question, so I don't do a triple question into one again. So I was thinking how will this impact Maltese obliged entities within the sectors and the new one captured by the regulation, especially when we talk about cryptocurrency. So one of the aspects of the regulation relates to, the removal completely of the anonymous e-wallet accounts, for example, when it comes to crypto transactions. And Malta has, focused in the last couple of years on creating an ecosystem to attract such businesses as well. And as you've rightly pointed, smaller operator, when it comes to EU regulation, doesn't always take into account or can apply across the board the principle of proportionality, which for an island like Malta is incredibly important. So how will this, in your opinion?
Yes, I mean, look, a lot of this depends on where you stand in the market and where you are in the market. So I think for a lot of firms, this new set of, this new regime isn't necessarily going to completely, isn't necessarily going to completely rock their world, right? Isn't necessarily going to completely turn everything upside down, which is quite different to what we saw with the fourth AML directive. So with the fourth AML directive, we saw changes that very extensively impacted, the day-to-day life of most subject persons. Before you didn't need to put together a business risk assessment, now you need to. Before there was much less emphasis on the customer risk assessment. Now customer risk assessment became an obligatory part of the process and a very important part of the process, right? So the AML4 directive had very direct impact on the life of many subject persons. The new package is, I think, going to have a more modest impact a more modest direct impact for many subject persons. Having said that, if you are within one of the industries which previously was not captured within the scope of AML regulation, AML directives, and now you are, obviously now you have a fairly mature and sophisticated rule book, which you now have to learn how to contend with, right? So for those people, there's probably going to be a big change, right? And if you are one of the entities which is going to be directly regulated under AMLA supervision, then again, there's going to be a whole new set of people to get used to, a whole new way of doing things to get used to. So for those people, it's going to be, again, more challenging. To be clear, this is not all, there's swings and roundabouts over here. I think there's a couple of important positives which we need to note, which is that we will hopefully enjoy far clearer and far more mature and far more harmonized rule set across the European Union. So we should have far fewer of those situations where one jurisdiction approaches, I don't know, customer due diligence in a certain way, and another jurisdiction adopts markedly different standards. And this is a product of the design of the new legislation. Effectively, in the past, in the past, we've always had a European directive, right? And directives obviously need to be transposed into local legislation, and the process of transposing always creates frictions and differences from one jurisdiction to the other. Now we're moving to a model which is kind of similar to what the bankers are used to. So the bankers are by now used to having like a capital requirements directive, the capital requirements regulation side by side with it, right? So we're going to have something like that for AML. We're going to have a directive which is going to, basically stipulate all of the high-level stuff about having an FIU and things like that. And accompanying it, we're going to have regulations, and the regulations are going to provide direct instruction about how to do things like perform a CDD, for example. And everyone is going to be subject to the same regulation across Europe, right? And that is hopefully going to iron out some of these creases that emerge as the different regulators implement different regulations. And if you're a pan-European business, like if you're a business coming to Malta, you're setting up your business in Malta and you want to do pan-European business, you now have a pretty strong message that the standards and procedures that you apply in Malta will pretty much be applicable in a very even and frictionless way, we hope, throughout the rest of the continent. So there are advantages over here. It's not just, more regulatory burden. It's hopefully also having less friction within the market as well.
And the clearer direction, as you've mentioned, when it comes to the onboarding, registration, and management of different customer profiles, because what happened at a point in time was the very heavy de-risking exercise, in the banking sector, for example, as we were talking about the banking side and how they have been used by the ECB regulations and liquidity ratios, capital limits, and so on and so forth. And with this, it could be, like you said, an advantage that it will create, for a better word, a level playing field across different EU states when it comes to the let's say transparency and methodology used by the regulators and the obliged entities.
Yeah, I think everyone of the practitioners over here will have the experience of, because this comes up with our clients all the time. All my clients come to me and they always ask me the same question. Why do I have to request all of these documents? Why do I have to go through all of these procedures, which nobody else on the planet needs to go through, which is bank, because the reality is what's happening is we have however many regulators in Europe. Everyone has his own slightly different way of doing things, but it's not that you're going overboard and nobody else is doing the same, right? And now what we're going to have, hopefully, is a situation where when you're doing the onboarding and you have these kinds of discussions, everyone can point to the exact same regulation, which applies in the exact same way throughout Europe, and say, provision XYZ indicates that the following should be done. This is the same wherever you go, so there shouldn't be any more of these debates. we hope, although I'm sure that somehow we will find a way to have these debates once again.
Oh no, absolutely, absolutely. I'm sure this will not go away, and customers will still be quite defensive, you know, or sometimes it's a lot of the times I found is the case of curiosity, you know, because we've been used in a certain way. So then when change does occur, it is natural that one will sort of raise question and will need that period of time to adapt themselves. We've got a question here, Charles. I'm going to read it to you. I mean, two questions, but I will start with the one that is most closely tied to the point of the discussion now, is that there are currently different standards for non-face-to-face online businesses in various EU markets. Will there be harmonization of these sectors once AMLA is in place? The person that asked the question, I assume you're referring to onboarding of customers in a online.
So. Yes, I believe so. One good thing which we have in Malta is, I think in Malta we've had a regulator in the form of the FIU that has been over time persuaded of the usefulness of non-face-to-face onboarding channels and has issued guidance in this respect. I believe we're also going to get some clarity in terms of European level when it comes to non-face-to-face processes. The AMLA has been tasked with the delivery not just of coordination between the authorities, but also of regulatory technical standards, which will hopefully address these things. So hold tight, and hopefully we will have this. One thing which I do need to highlight over here, however, is that remember everything that we're talking about is in proposal stage. There's a 2 to 3 year time horizon for everything that we are talking about. The European process can be quite lengthy, and there may be revisions in the future. So we'll need to see in what the detail of what eventually comes out of this process. But the answer is hopefully yes. But let's wait and see.
Exactly. I mean, there is still some time ahead. From the latest discussions at the EU level, the AMLA authority would be up and running, let's say, from 2024, but it wouldn't have necessarily immediate scope from an enforcement point of view. So that gives EU jurisdictions a lot of time to, have discussions like we're having today, and really understand what these changes can mean and what the proportionality is for each stage, and how firms can better prepare, and how professionals as well can better prepare themselves, so that if it does reach this shape and form, eventually we are not completely caught by surprise. There is another question related to the, let's say, competitiveness in Malta, and whether the introduction of the new regulations and the increased regulatory supervision will affect Malta's, affect probably is not the right word, but let's say, will affect, because I can't think of any other, Malta's edge as a lower cost option when accessing the European market.
Actually, I think that if anything, the single rule book will enhance the attractiveness of the jurisdiction. I don't think it will take away from the attractiveness of the jurisdiction. And let's set the scene. Everyone knows that Malta was grey listed by the FATF. We spent a year on the grey list. There was a process which we undertook. I think there was a tremendous effort on the part of authorities, regulators, and stakeholders in order to make sure that standards were duly improved, and I think a lot of improvement was indeed registered. Of course, this is an ongoing battle and it's never really done, but a lot of improvement indeed was registered. So I think Malta, in terms of, let's say, the procedural side and the structural side, has actually registered a lot of improvement, and in a way, a lot of the a lot of the pain has been absorbed already. Now we've taken it in our stride and it's become part of our new normal. So actually having a European level regulation that harmonizes these expectations across the board makes sure that we are competing on a level playing field where everyone is at the level which we have now achieved, right? And also I think a good thing is this development will hopefully take away a lot of the ambiguity from the different jurisdictional interpretations, right? And allow the jurisdiction to compete based on substantive matters rather than on whatever ambiguities could arise between one jurisdiction and the other. So actually my view is not only does Malta not lose its competitive edge as a result of this, but if anything, I think Malta gains from there being a more frictionless market also in the context of AML CFT.
Definitely, I think we're in a sentiment that Charles, it is great progress has been made to date, and this would just help to really put Malta on the map alongside other jurisdictions. And then when we look at the cost perspective, which is one of the, let's say, concern points raised in the question, with the continuous development, as we said at the beginning, of the regulatory regime, but not only on the AML CFT front, we've got on the ICT front, on the technology front, and in so many other areas, is that essentially from, let's say, being highly, sort of tight with one's investment into a business, whether that goes towards AML, CFT, tech, or any other matter, is long time gone, because we are heading towards increased harmonization. We are heading towards more uniform, let's say, onboarding processes and expectations as well from a regulatory, but also from a consumer point of view. And I think this is something we sometimes forget as professionals, because we are very focused on the legal side, on the regulatory side, but we forget that also consumers have become a lot more sophisticated, more demanding as well. So it's important to be able to satisfy that change in consumer behavior, whether it's a corporate or a retail consumer alike.
Look, I fully agree. Look, I think there's a message here, which is that AML CFT compliance and anti-financial crime compliance in general isn't going anywhere, right? So as a jurisdiction, we have successfully exited the grey listing process that entailed a very steep learning curve and a relatively quick and fast-paced change in how we did various things within the jurisdiction. I think that change has now been accomplished. What I think is that now becomes sort of the new normal for us, right? So I don't expect to see any major change or softening, or we'll call it what you will, post grey listing in terms of the expectations of regulators. I think this now becomes a new normal. You can see that the driver behind this isn't just FATF, right, but is also these European level efforts, where we're going to have not just a more harmonized approach, but we're also going to have a European level regulator, which is going to, on a consistent basis, be pushing the local regulators, the domestic regulators, towards ensuring that the standards are adhered to. So my message to subject persons is, look, AML CFT compliance and anti-financial crime compliance is, well, first of all, it's done well. It's a socially useful thing, right? So we all benefit from a market where criminal funds are not allowed to flow freely. So at the end of the day, this done well, this is a social good. Now, the second thing is, of course, it will never not be a burden, at least to some extent, right? So it's never going to be a walk in the park. It's never going to make your life extraordinarily easier, right? However, if it is done well, it doesn't need to be very painful, and it can be very much like the whole AML framework can be integrated within your day-to-day life, such that it becomes second nature, and it doesn't become a very painful and sort of a sore spot in your process. And in our experience, we've assisted many clients across the industry spectrum in ensuring not just that they are compliant, right, but also in ensuring that they are compliant in a smart way. And so many times, we deal with subject persons and, try to understand how they're doing things. And they're very comfortable that they're doing things well because they have a big stack of documents, this big, they have a customer file, and it's like 4 kilograms of customer file, and we look at it and we're like, this isn't very good, and they're surprised. And then we tell them, like, actually, this is what good looks like, and it's something which is a lot more frictionless, a lot actually simpler to execute, right? But it's the right thing to do. So my message to subject persons is, this isn't going away. There's further drivers behind it. The best way to deal with it is to make sure you understand what you need to do, and to do it in a smart and efficient way.
Definitely, and the single AML rulebook and so on will definitely assist towards that, because of the clarity element that it will bring in that respect. As we said at the beginning, that these are ongoing talks, so we're not expecting any immediate changes to the regime, but it's also very good to be prepared for it. One of the questions here that we've also received is with regards to let's have a quick look. Okay. So whether other players, such as insurance companies, crypto, will benefit of more clearer requirements insofar as AML and CFT is concerned.
I think well, I'm going to stick my neck out over here, and I think the answer to that is a clear yes. Now, if 3-4 years down the line this doesn't pan out, please don't show up at my door, But jokes apart, look, I think the answer is yes, because I think, for what it's worth, right, if you are outside, or sort of your status within the directives was a bit murky, and now you've been clearly captured, right, you're not being sort of dragged into a regulatory framework which is new or immature or anything of the sort, right? The AML CFT framework now has been around for a number of for decades. You can see when you read the draft regulations that there's a lot of maturity now in terms of thinking about these things. It's a lot more granular than anything we've ever had before. So I think you're going to be brought into a regulatory framework which is quite extensive, which benefits from a lot of experience that has been poured into it over the years. So I would say that overall, yes, you will enjoy greater clarity. You will enjoy greater granularity going on the drafts as they stand right now.
Thank you, Charles. And how will the role of the MLRO officer, let's start with the MLRO officer, will look in the post-single AML regulatory world? What changes can professionals expect?
I think we're going to see a continuation of like a phenomenon which we've been seeing for a while now, which is the increasing importance and seniority of the MLRO function. I think going back, 10 years ago, which is not that long ago, right? I think in many instances we would see MLROs who would either be, for example, one of the partners of a firm, one of the directors of a firm, who held the role among a million other roles, and it was, perhaps something which wasn't really foremost on their minds, or it's something which we used to see. You'd see relatively junior people holding on the MLRO position because it was maybe perceived as being a kind of administrative function, right? That has changed very dramatically. I think the MLRO has to be perceived as part of the senior management of the firm. And this is not just because the rules will usually say so, right? But also because it's kind of impossible to run a subject person well if you don't have maturity in terms of your MLROs. And when you have MLROs who are not strong as professionals, you end up with one of two permutations. You either get an MLRO who says no to everything, right? Which is very easy, but then you're out of business in a month. Or else you get an MLRO who says yes to everything, which again is very easy, but then you're out of business 2 years later and more catastrophically. And it's very difficult and very challenging to find people who are mature MLROs who can look at risk in a very pragmatic, objective, and at the same time prudent way, and make risk-sensitive decisions. And not only that, but also have the courage to then revise those decisions from time to time as the evidence, as the behavior of the customer, of the situation evolves, right? So what I would say is we're going to continue seeing more of this. You know, this new rule book doesn't in any way, you know, overturn the notion of what an MLRO is, right? So the core functions of the MLRO kind of remain the same. So that hasn't changed. But now we are in a world where we have a very long-standing, mature rule book. We have local regulators who are a lot savvier. We have supranational regulators chasing after those local regulators, right? And all of that is going to conspire to require professionals who are very, very capable and mature. So I think what organizations need to make sure of is that either they have these capabilities in-house, or they are supported, because the MLRO is going to be, you know, a core part of your C-suite in a way, a core part of your, you know, decision-making process, in the way that your chief financial officer is, or your chief commercial officer. You know, it's another core part of the process. So I think that's like my first observation, at least.
I completely agree with you, Charles. It will definitely not, you know, bring any significant changes to the function in itself, or to the PQ process, for example, as this was one of the questions here in the chat with regards to the PQ. But it will definitely enhance the role of the MLRO within the function of a business, from a decision-making perspective, as well as from a continuous development perspective. I mean, as a headhunter specializing in one of these areas, compliance and AML, if I would have, you know, a penny for every time people said, you know, where can we find compliance AML people, I would be, you know, significantly wealthy. And it has been a challenge, not only locally, but also across the EU, to recruit and retain such professionals. And one of the challenges that have been identified in firms that do require specialist AML and compliance individuals is that many a times we sort of take a reactive stance, which means, you know, regulations come through and then we see what we're going to do. So that puts a lot of pressure on the firm. This is where the costing tend to increase as well. And this is where, Charles, you probably get a lot of calls at 12 o'clock at night telling you, you know, we need your help now. Whereas if we are a lot more proactive, we can reduce, let's say, the friction of immediate demand, which reflects into the MLRO's role. So succession planning and professional development are important areas, but it's still very much not, I wouldn't say very uniform at this level either. Okay, we have, you know, a lot of different institutes, you know, you have the diplomas in anti-money laundering, and you were talking about seniority, but how can this be continuously sustained as well? I think that's
very good question. And I don't think anyone has a perfect answer to this, right? Look, one good thing is, I think nowadays there's plenty of training. There's plenty of training out there, right? So in terms of, I think getting formal education, which is useful, which is important, and regulators will expect it. I think there are, you know, various options available nowadays, even here locally. But I think the difficulty is that at the end of the day, you cannot educate someone into being a good MLRO simply through academic processes. You know, someone has to be made has to make themselves into a good MLRO, and it requires a pretty particular set of skills, right? Because ideally you need someone who has both an in-depth knowledge of financial crime per se, right? That ought to be a given, right? So that's obviously important. Apart from that, you also need someone who has a good understanding of the business areas in which they are operating in. Useless knowing all of the academia about financial crime if then you don't understand the business models that you are supporting, right? Thirdly, you need a good governance structure within which the MLRO can operate. Even the most capable MLRO on the planet will not be effective if everything they propose can be simply shut down by sort of a very strong-willed chief executive officer or something like that, right? You need a good governance structure within which the MLRO can function properly. And finally, you need MLROs who have the experience and personality and intellectual capability to fulfill the role properly, which effectively means you need people who understand that no business is entirely zero risk, right? And who at the same time are very, very keen to safeguard the institution that they are actually working for, and who can let's say analyze risk in a sound way, and understands which risks can be taken on sustainably and which risks simply cannot be taken on, and then have the strength of character of pushing that point across, you know. So, you know, you need someone who is quite strong in a number of areas for them to be an effective MLRO. And it's just the case that that set of capabilities is not very easy to come by. We see this in our practice a lot. Like, many of our customers are actually organizations that do have compliance teams and that do know what AML is, and, you know, and they're no spring chickens. They've been around for a while, and they know what it entails to run a compliance department. However, they often find that they're lacking, you know, they might have a good team, but they're lacking seniority, or is they have a good manager, but this manager is supported by a relatively junior team and needs senior level support, even just, you know, someone to bounce ideas off. That's a big chunk of what we do, because there is now a very big need for AML CFT expertise, and we're still in the process of building up that capacity within the jurisdiction.
Definitely. And especially when it comes to the corporate governance structures, as you rightly pointed, this is something that comes a lot from a cultural dynamics perspective within the firm, to ensure that the, you know, for a better word, the structural integrity of the business, of the operations, of the procedures is solid, so that the MLRO can operate effectively ultimately. Because if there is chaos, or like you said, the senior management that is outside of the compliance CFT sphere interferes in the decision-making process, then of course the whole scope of it, apart from being, you know, quite against the regulations, it's not a good idea to do that. It defeats the whole purpose to have an individual at senior level to perform that function in itself, you know, from a professional point of view. And we've touched upon the MLRO, and, you know, there has been very good guidance in the market with regards to the role of the MLRO, especially, I think it was a couple of months back that it was addressed both in the financial services as well as the iGaming context, particularly from a personal liability perspective. But one of the areas that is kind of left out, which I think is important in the overall context of change of the single rule book, is the function of regulatory compliance officers, you know, versus legal. Yeah. There's always a contention point there, and it's very unclear.
Very good question. We get asked this question all the time. So let's be clear. The single rule book is, you know, this is for AML CFT, right? And from an AML CFT perspective, the key officer of the company, you know, other than the members of the board, is the MLRO. Now, AML CFT although it has tended to, capture the imagination and grab all of the headlines over the last couple of years locally, it's not the be-all and end-all of regulation. So any bank, any corporate service provider, any regulatory and regulated entity will have a whole other host of rules to contend with, and each one of these could be a field of expertise in its own right? So that is where the compliance officer within most jurisdictions comes in. These rules will tend to be, conduct of business related, or related to how we treat customers in a fair manner, how we deal with complaints, how we deal with a host of other things which could be subject to regulation, and that is
soft law.
Well, I mean, some of it maybe you could call it soft law. Some of it can actually be fairly hard and precise. Like in the investment services world, there are very specific ways of how you can promote an investment or sell an investment to a customer. And these are, fields of law which are just as sophisticated and granular and detailed as the AML CFT framework. So that is where the compliance officer tends to come in. What we have seen and what we are seeing is that as the different rule books become more and more sophisticated, and as an organization grows larger and larger, it becomes more and more difficult to combine these two functions, combine the MLRO and combine the compliance officer. Within smaller organizations, it's relatively commonplace and generally acceptable to regulators to combine these functions. But as an organization grows large enough, right, it becomes very hard to sustain. Like if you're a small payment services provider, you might be able to do it, for example, but that's probably the borderline. Like if you're a large payment services provider, or you're a bank, probably of any scale, it's going to become unsustainable very, very quickly. If you're a corporate services provider, you can probably combine the two, just because the non-AML CFT component of regulation isn't that huge, right? But for many other fields, it's going to be impossible to combine the two roles in one person as you achieve scale.
Absolutely. And do you think that there will be the possibility of appointing sort of designated employees without going through the PQ, or that won't be affected in the market? That's one of the questions.
One second. Off the top of my head, I'm not even sure you need a PQ for a designated employee as of right now. But I wouldn't put my hand in the fire over there. But I think you don't need it. I'm not entirely sure though. Sorry.
At the moment is on the functions of the MLRO, for example, and then the chief compliance officer and so on. But the person that asked the question, if you could perhaps clarify a bit more. Maybe if we have time later, we can come back to it to see.
I don't think to appoint a designated employee, you need an MFSA permission. I think you need to enroll them with the FIAU. But I don't think the designated employee being like sort of the deputy or the delegate of the MLRO.
Exactly. They don't need the PQ. It's on the other end of the spectrum, unless the question can be, to make sure I understood the question correctly. If we didn't, just retype, and we will come back to it. And one of the other questions is with regards to expectations from the authorities' point of view, such as the MFSA is mentioned here, FIAU, MBR, etc. Some individuals feel that these authorities have different expectations from CSPs, and it became very confusing for MLROs with regards to what documentation they should obtain from their clients, both during the onboarding stage as long as in terms of the ongoing relationship and maintaining the relationship stage.
Yes, look, this is a very good observation. And if you are finding certain things a bit confusing, I can just sort of sleep easy at night. You're not losing your mind. It is because certain things are indeed confusing. And this is by virtue of the fact primarily that we had an AML4 directive, right, which stipulates a number of things, and among them we have beneficial ownership transparency rules. Now, the implementation and supervision of beneficial ownership transparency rules has largely fallen to the Malta Business Registry, the MBR, while the rest of the rulebook is largely within the responsibility of the FIU. Having said that, it's not that the FIU takes zero interest in the identification of beneficial owners, etc. It's still one of the core things which they are interested in. So now we have two regulators who are kind of looking at some of the same things. The MBR historically has been more mechanical as a regulator. Now it's changed a lot. It's become a lot more qualitative as a regulator, right? They're much more interested in the substance of things. They have a very active compliance department. So this is a massive, massive change. And we are seeing, that I won't go into detail, but sometimes you see diverging interpretations of the same thing between one regulator and the other. What I can say is that at least on the part of shoulder compliance, we are in dialogue with both the FIU as well as with the MBR. We have been encouraging them to have more dialogue. I know that they do have dialogue, so it's not that they're not making an effort to align, but I do personally think that more can be done. And there's half a dozen or so pain points where if we get a bit more cohesion, we would benefit. Again, hopefully having a single rule book will help to iron out some of those things, and having regulations as opposed to directives will help to iron out some of those things. But then again, the single rule book is 2-3 years away, and we really shouldn't wait that long as a jurisdiction to iron out some of the internal confusions that have arisen. I know that there's work taking place on these issues. I don't know the timelines for it.
Fair enough, Charles. And thank you for that. And I think everyone is in a sentiment when we say that we need to look forward and preempt any potential misunderstandings or lack of clarifications and so on and so forth to prepare us both in the current shape and form. As you said, nothing is going to change immediately. Sort of tomorrow, we're not going to end up feet first into a new AML CFT world, but
I think we got a clarification on the other question. Basically,
have we?
Okay. So all right. So I think this is all right. So what I think the clarification is this. So yes, PQ is not required for an MLRO delegate, but some managers view this as a way to short circuit MLROs they see as being too strict, right? So maybe you appoint an MLRO delegate, right? And the MLRO delegate will, look, to be honest, if some people are going down that road and they are doing that, I think they're just asking for trouble, to be honest. All of the powers granted by statute to the MLRO pertain to the MLRO by virtue of their office. If an MLRO resigns because they feel that they are being undermined, remember they are actually required to notify the regulator to flag if there were, regulatory issues of this type, right? You can rest assured that if your MLRO resigns because of concerns of this type and they flag it, that will definitely land somewhere near the top of the pile of the FIU, probably the MFSA as well. And that will almost certainly lead to regulatory repercussions. The right way to do this is there needs to be good governance, there needs to be a good culture, there needs to be a good fit. The MLRO and the executives need to have good dialogue between them. And if they're not comfortable with how they work, and this can happen even without any financial crime risk, right? Because people have different personalities and ambitions, and there can always be personal differences. The right way to do this is to simply part ways amicably and not to try to circumvent and short circuit the MLRO, which will surely land the subject person in trouble. So I understand why it might happen. I think it's just a very bad idea.
Yeah, absolutely, definitely. I hope that answered the question. Thank you for clarifying and thank you for answering this, Charles, and highlighting the importance of corporate governance and professional conduit as well. I think that's really critical. I think we've got time for one more question. So essentially, it refers that at the moment, the FIU allows for the appointment of a separate officer to the MLRO to, let's say, monitor the day-to-day application of measures, policies, and ensures that the AML CFT obligations are adhered to. On the other hand, the EU legislation does not seem to draw this particular distinction.
I don't think there's going to be any issue with that distinction going forward. So I think that the definition of the role of the MLRO isn't going to change in any major way, at least according to the current draft, right? So sort of the MLRO's core role remains, like, let's say, overall oversight of the program, and most importantly, the identification and reporting of suspicious transactions. It is only natural that, especially with larger organizations, there may be people who are tasked with the supervision of the implementation of this program. It's a model which is quite in widespread use within large organizations. I don't think there's going to be any major change or objection to that. There was also, if you don't mind, I think there was a question which I think was quite interesting, which we might have missed, Fran, which related to the impact on, like, the treatment of third countries and jurisdiction risk assessments.
Let me find it. Yes, okay. So I found it with regards to jurisdictional risk assessment. So what do you anticipate would be the impact of the single rule book in the jurisdiction risk assessment that are currently used by subject person or entities?
I thought this was I think it's actually quite a useful question to pick up on, just because it allows us to bring up another element of the single rule book, which I haven't really spoken about, which is how we deal with high risk jurisdictions, right? So what is actually quite interesting is that by now in Malta, everyone is familiar with the famous Financial Action Task Force, the FATF, which issues the so-called grey listing, right? Now, what we're going to see, which is I think an important and useful change, is that the FATF is going to be given standing directly within the rule book, and if an entity is grey listed or blacklisted by the FATF, that is recognized directly within the rule book as being, a good enough rationale in order to subject entities related to the jurisdiction to enhanced due diligence. We're kind of there already in a sort of roundabout way, because the rules will kind of nudge you towards dealing on the basis of EDD with any entity which is grey listed or blacklisted by the FATF, right? But now the European authorities are effectively absorbing the FATF's pronouncements into their legislative process, and I think that's helpful, right? I think that's helpful. It's not going to be the case that the Commission is going to abandon its ability to designate other countries as being high risk. So Europe is going to retain that ability, but it's going to be over and above whatever comes out from the FATF, which would again help to reduce a little bit of the fragmentation that we see, and hopefully make jurisdiction risk assessments a bit more consistent. We're not going to have a removal of the requirement to perform jurisdiction risk assessment, right? So we will still have some firms which look at some jurisdictions in a certain way and look at others in a different way. That's not going to go away, right? However, we do get a helpful nudge.
Thank you, Charles. And thank you everyone for the questions that you said. They have been certainly incredibly interesting. We're up to 1 hour more or less, and we've kind of reached the end. I'm sure we could be debating and talking about this for many hours to come, and I'm sure there will be opportunities to continue to explore this subject further, especially as it continues to be drafted at an EU level. So thank you, Charles, very much for your thoughts. And now I will pass the floor over to Ivan for the closing remarks, and thank you everyone for joining us and sharing your afternoon with us today.
Thank you. Thanks.
Thank you very much. Thank you, Fran and Charles, for this very insightful and interesting discussion that we had. You've provided much food for thought to all of us with regards to the challenges and opportunities facing compliance and MLROs. So thank you very much in that respect. And yes, I think we could have gone on for another hour actually, and it's never enough. I also thank all the participants for joining us this afternoon. And I'd like to remind everyone about the forthcoming 15th Finance Malta Annual Conference, which will be held between the 30th November and the 1st of December in physical format, finally, from 2019. So, stay tuned for more information in that regard. Follow us on LinkedIn, Facebook, Twitter, YouTube, all the social media channels, and including our website as well. So thank you once again, Fran and Charles, and I wish everybody a pleasant rest of the afternoon. Thank you very much.
Thank you. Thanks.
Thank you, everyone. Goodbye.